All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Before we get started with our cases today, I just wanted to acknowledge this is our first argument since the retirement of our colleague, Justice Ricky Polston, and wanted to thank him for his excellent service to the court, his companionship, friendship. He is a great guy, and we all are going to miss working with him, and just wanted to acknowledge his great service to the state and to the people of our state. We're going to hear our first two cases today and then take a brief break and then hear the last two. The first case today is number 22-1084, In Re Amendments to Florida Rule of Appellate Procedure 9.130.
Good morning, Chief Justice, Justices. May it please the Court. Aaron Daniel from Kuhl & Associates on behalf of the Florida Bar's Appellate Court Rules Committee. Committee petitions this Court to amend Rule 9.130 to include review of non-final orders that deny motions under Florida Statute Sections 768.295, Subpart 4. The proposal that you have before you today was unanimously passed by the full committee, and I'd like to explain the committee's deliberation process for the court. So this referral emerged from a conflict between the district courts of appeal, initially between the second and the fourth, on whether or not these SLAP being strategic lawsuits against public participation, these anti-SLAP motions, orders on these motions, were reviewable by certiorari. And so the committee received this referral and looked to primarily a case that both of the initial conflict cases cited, the Keck versus Immunizer case from this court, in which this court articulated 4 factors that it would analyze in determining whether to expand non-final jurisdiction. And so that's the guidepost that the committee used. And the first factor, of course, being the nature of the rights involved. Here we have very weighty rights involved, of course, constitutional rights to freedom of speech, as well as substantive rights granted in the statute designed to protect those constitutional rights. So it seems like part of what's going on here involves what you're getting to with understanding what the statute is, what it does, and it seems like the court, there's not a sort of uniform view as to what that is. I know there's some federal courts that have described it as basically just a fee-shifting statute, and think that a lot of the stuff in here is kind of hortatory. I mean, do we need to sort of have a fixed view of how to resolve those issues in order for us to make an informed judgment as to whether to adopt this rule amendment? So 2 responses to that, Your Honor. The first is that at the time that the committee deliberated on this and then voted and then submitted its petition even, there wasn't much of a debate over what the statute was. Both the second and the fourth likened it to immunity from suit. And that's based on the language of the statute and the rights granted therein, and as Your Honor pointed out, the hortatory language. Subsequently, there was the Lamb decision out of the third DCA that did bring up this issue of, well, maybe it's just the Lamb decision said it's just a fee-shifting statute. Now, that decision was not a decision that concerned reviewability. It was a final appeal determining the burden shifting, whether or not there was burden shifting involved. So a merits issue. But nonetheless, so that was where the committee stood and explains why the committee came out the way it did. At the time, there wasn't much of a debate on this. Now, there appears to be some debate, but in the committee's view, and this is discussed a little bit in our response to the comment from the opposing law firm, even if it's something that is less than a protection from immunity from suit, it is an irreparable harm that the movements experience when they are not allowed immediate review. You cannot get your right to an expeditious resolution, which is the statutory language, back on plenary appeal. You can't get the right.
But really, though, I mean, the irreparable harm thing really does seem like it depends on an analogy to the immunity in the sense that we just, in general, as much as nobody likes to be subjected to a meritless, ultimately meritless litigation, we don't typically view that as irreparable harm, right?
Correct, Your Honor. And again, the difference here, this is kind of a unique situation where the harms also stem from the chilling effects that such meritless lawsuits have.
Can I ask you on that?
Yes.
So it seems like the language of the statute here is kind of strange. I mean, when it says that the claims are without merit, that's just kind of a regular thing. And then it says primarily because such person or entity has exercised the constitutional right of free speech. It seems like there's some cases that interpret this primarily because stuff is essentially just, does it arise out of free speech? But then if you read sort of the kind of the context for this, it seems like it's almost like a retaliation type thing. And I'm kind of wondering what is it that the court is supposed to be deciding at this early stage? I mean, obviously the without merit, certainly at a motion to dismiss stage, it's just going to be based on, the allegations in the complaint. The primarily because such person or entity has exercised the rights, is the court just going to look at whether the substance of the lawsuit has to do with a speech related thing, or are they going to be looking at, someone's motive for bringing it, or if it's animus or something? I mean, part of what I'm struggling with is, in order to decide whether it makes sense to have an immediate appeal, you have to kind of have a sense of what are the types of decisions that are going to be made here. So what's your take on that?
That's exactly right, Your Honor. And this is something that the committee and the subcommittee that was tasked with looking at this wrestled with, because there is debate over exactly that. What is the court, the trial court, and then the appellate court looking at the trial court's order supposed to determine? Is it some kind of animus? Is it some kind of intent? Or is it just lining up, the claims and seeing whether they fall within the protected activity within the statute? And those are open questions. And the committee didn't feel like it was in the position to make those determinations other than to flag them and to propose an amendment that would not narrowly constrain review, but that would allow review to resolve these questions. And so it's propitious that while we now have this petition to amend the rules pending, there are merits cases pending before the court on the reviewability issue. And so I would submit, and the committee would submit, that to resolve these substantive issues, it perhaps makes the most sense to resolve those in the merits cases first, with the pending rules case as the vehicle to review. And this is what the court did in the Beach Community Bank versus City of Freeport case when it amended the rules to allow review of sovereign immunity. That's 150 Southern 3rd 1111. The same day decided the rules amendment and said we're reviewing sovereign immunity, and then determined and explained in the merits cases the decision for doing that and reviewed the merits of those cases. This court also did a similar, used a similar vehicle with FHP versus Jackson, again with immunity issues, and explained its rationale for amending the rule, and then sua sponte amended the rule to allow review of the pending cases. So,
and so what should we make of the fact that a plaintiff who is faces a motion that this was a violation, if they prevail, they can actually get attorney's fees. I mean, that just strikes me as kind of going against the idea that this is some extraordinary, immunity-related thing. I mean, it does. I mean, this is a very odd statute. So what are the attorney's fees that the plaintiff would be entitled to, just for the litigating the issue of whether it violated SLAPP or the whole shebang?
That is also, I believe, an open question. I believe there are some perhaps federal court cases that that may have come one way or the other. And so, again, the committee didn't determine that question of what type of fees, but the committee did look at the fee provision within the context of whether or not this is going to add to the court's workload or add delay to the process through a non-final appeal, and because of that disincentive to file a bad faith anti-SLAPP motion because of the fees, the committee looked at that and said, okay, well this isn't going to add to the delay. The statute already has safeguards in place. So that's the extent of the analysis of the fees that the committee looked at.
Can I ask a question about the number of times, the way it's written? Could someone bring a motion to dismiss, appeal that, and then later bring a motion for summary judgment and appeal that?
Yes, Your Honor.
So there could be multiple appeals. Is there any concern about the delay that would potentially cause?
So there certainly could be multiple appeals arising out of this. First, a motion to desist, a motion for summary judgment. There also seems to be some third. It almost seems like there's three types of motions within the statutory language, right? That motion to dismiss, motion for final judgment in favor of that party, and then this motion for summary judgment, quote, seeking a determination that the lawsuit was brought in violation. Those might be different. The committee wasn't sure, and that's why the committee is keeping it broad so that these substantive issues can be resolved. However, when it comes to delay and successive motions, we see this in the sovereign immunity context and other immunity contexts where you have motions to dismiss, denied, an appeal, and then motion for summary judgment, denied, and an appeal. So in, again, those immunity contexts, it is something that occurs. And going back to the delay, it is important to note that the statute itself doesn't have an automatic stay provision, and the committee is not suggesting there be an automatic stay provision. Stays of the litigation in the trial court remain within the discretion of the trial judge. And so if there is a bad faith motion that's filed and denied on the basis that the trial judge believes it to be bad faith, the trial judge can deny a stay of litigation pending any non-final appeals. And so I think the statute already contains some safeguards against the delay that you're suggesting, Your Honor.
Thanks. And you can have 2 minutes for rebuttal.
Thank you.
Thanks.
May it please the court, my name is Matt Canigliaro. I am with Carlton Fields, and I'm here today on behalf of the Media and Communications Law Committee. I'm going to try to make a few quick points in my few minutes with the court. First, we support amending the rule. To do that would effectuate the statutory right, and at the same time, to not amend the rule would actually diminish the statutory right. And let me try to put a bit of a pin in what right I mean. The language in the statute says that a person sued has a right to expeditious resolution of a claim the suit is in violation of the statute. So it's a statutory right to expeditious resolution of your argument that this has been brought in violation. And so obviously the legislature is limited in how much it can control of the process in the court system, but the legislature has done its best to say what it would like to see happen here. And this court's way of effectuating that right in this context would be to allow 9.130 to be to provide for interlocutory review.
I'm sympathetic to that because it does strike me that if we're going to give effect to the statute, I hear you. I guess the struggle is reconciling it with our decision in Keck. And I think what you're hearing from a number of my colleagues, and what I'd ask you to address is that third prong about whether the issues posed by any one of these motions is, wound up with factual issues about, for example, what specifically was protected speech about the underlying allegation, or what the degree of expenditure is by the parties in defending a claim. These factual issues weigh in our analysis about whether to use cert, even though we're sympathetic to with a clear legislative bargain here, which is move these along quickly. What can you say to address the fact that, as your colleague has said, so many of these questions are just left open by the committee?
I'll try to address that and one of the court's earlier questions at the same time. These are things that the DCAs do. Review of an order granting or perhaps denying a motion to dismiss would be de novo. It's a legal question. And same thing on summary judgment. An order granting or denying a summary judgment is reviewed de novo. And the DCAs do these things. And I'll point to the other provision in 9.130 that deals with injunctions. We have basically an order granting, denying, or modifying, or not granting, denying, or modifying an injunction can be reviewed. In theory, you could have successive appeals in any case involving an injunction. In practice, we really don't see it, not as a problem. And here, I would suggest that in the end, the simple answer is the DCAs would resolve these appeals by just looking at the record. If there were factual issues, that would preclude summary judgment. If there were factual issues, that would preclude a dismissal. But if there are not, then that relief should have been granted, and that's exactly what the DCA would review. If I could try to address quickly sort of two related thoughts. First, the pipeline cases. As was alluded to earlier, there are many. Some are in this court as tag cases. There are many in the DCAs. We would ask the court to be, first, of course, to amend, but second, in doing that, to be mindful of those cases and to consider amending in a way that would allow the amendment to apply to existing cases in the pipeline so that they can have what I'll say is take advantage of the amendments. That would be consistent with the statutory language about an expeditious resolution. And the third thing, we noted it in our comment, and I'll just mention it quickly here. There are two other SLAPP statutes in our statutes, one in 720 and one in 718. One concerns homeowners or property owners. The other concerns condo owners. It's the same right, slightly different damages if relief is awarded, but the same right, that expeditious resolution of the claim or the argument that the suit has been brought in violation of the statute. And we would ask the court to consider not just the statutory reference to 768, but to the other statutes as well.
What do you make of the argument that, if the legislature really wants to do something about this, they should put some more meat on the bone themselves, like some of the other states have done by explicitly writing into the statute kind of, burden shifting or different procedures? I mean, this really just reads like you can file a motion to dismiss, you can file a motion for summary judgment. The statute itself, it's not obvious what's even supposed to be in dispute. It talks about the supplemental affidavits. I don't know what those are supposed to be going to that's over and above the merits of the, you know what I mean? Why should we be, you can get a prompt resolution from the trial court. The issue of the appellate review is a different, kind of a separate issue. I mean, why should we be trying to address that?
I think the answer is in the phrase expeditious resolution. It's not just a determination, it's resolution. And to get resolution on these issues, if you are the movant here and your motion has been denied, is to get review. And that's what 9.130 is there for. This court is the only entity in Florida that can decide to allow that sort of review, and that's why we ask for it. Thank you.
Good morning, Mr. Chief Justice, and may it please the court. I'm Dylan Esper, arguing against the rule change. I want to start by addressing 2 points that were made by my friends over here. Firstly, on this issue of expeditious review, it's important as a matter of statutory interpretation to note that that's in Clause 4 of the anti-SLAPP statute. And under nocitur sociis, you look at the words around that wording in Clause 4 to determine what it means. And if you look at that, that's a clause all about trial courts. It says expeditious review, and then it says the trial court is going to hear a motion to dismiss or a motion for summary judgment. It has the supplemental affidavit language that's a little bit confusing, which is also, of course, going to be filed in the trial court. It talks about the fees and damages that are going to be awarded in the trial court, and it talks about the calendar preference that's going to be awarded in the trial court. So all of those things that our expeditious review is referring to are trial court rights. It doesn't say anything about appeals. And indeed, when you think about expedition on appeal, the policy arguments are totally different, because expedition on appeal also has to take into account the fact that if litigants are going to possibly get 2 bites of the apple here, a review of a motion to dismiss and then a review of a motion for summary judgment, these cases actually might not be expedited at all. They may drag on, and they may be stopped twice in the middle of trial court proceedings for an appeal to take place. That's not expedition, and that's not consistent with anything in the legislative intent. The second point I wanted to make about arguments made by my friends is about this open question. I heard it referred to 3 times that the committee found certain questions to be open, including one of the basic questions under this court's Keck test, which is the issue of whether there are factual issues on these appeals. It's an open question. This court was told whether or not that language in the SLAPP statute about the filing being made primarily because of the exercise of constitutional rights refers just to the issue that there's a First Amendment issue in the pleadings, or whether it refers to the plaintiff's motive in filing. Well, that's crucial to determining whether there should be a rule change or not. On the one hand, if it is just a matter of there's a First Amendment issue in the pleadings, that might point one way under the Keck test. But on the other, and this, by the way, is the way I read the statute, that the court is supposed to inquire as to the motive of the filing and whether it was primarily, that's a word that describes motive, filed because of the exercise of constitutional rights. Primarily is important because that's a word that describes weighing. There can be multiple motives to file a suit. You wouldn't say primarily if it was just a matter of what's in the pleading. You say primarily filed because you're going to say, well, did they file it for the reason of suppressing someone's constitutional rights, or did they file it because there was some valid reason to file it? And if that's the inquiry being made, then that's factual. And there's no way to advance a rule change of this magnitude and to say that every anti-SLAPP defendant is going to get possibly 2 non-final appeals in their case without even knowing whether the issues involved are going to be factual issues regarding to the motives of the plaintiff with respect to filing the case. And I would add one more thing about that, which is if I'm right that this statute asks for a factual inquiry, that militates strongly in favor of waiting until the end of the case for the appeal, because at that point you're going to have a trial record, you're going to have testimony, you're going to have witnesses, you're going to have documents. You're going to have a lot of stuff in front of the Court of Appeal from which they can discern whether or not the case was primarily filed to suppress constitutional rights or not. Whereas if every case is going to go up on interlocutory appeal after a motion to dismiss, you're not going to have that. What you're going to have instead is you're going to have very cold records with just a complaint and some briefing on the motion to dismiss, and courts of appeals are going to be trying to determine the primary motive for the filing. And that's a purely factual issue, and that's not the type of thing that under the Keck test should be heard on an interlocutory appeal. What I want to say about the statute itself is fundamentally it doesn't create immunity. It doesn't state that it creates immunity. Statutes that create immunity clearly say so. For instance, it's in the same chapter as the SLAPP statute is 768.39 Florida statutes. That statute is entitled Immunity for Educational Institutions for Actions Relating to the COVID-19 Pandemic. As you can tell from that title, it was passed recently. This is the Florida legislature recently granting a class of defendants immunity. And it says in its operative language, quote, may not be held liable for and shall be immune from. That's what you see in a statute that grants immunity. There's no such language in the SLAPP statute. The SLAPP statute contains a lot of language condemning SLAPP suits. It says they shouldn't be filed. We don't deny that. It is very condemnatory of SLAPP suits. But the remedy that it creates for that is, as Your Honors have intimated, a form of fee shifting. The theory the legislature was operating under was that if you're a plaintiff and you're considering filing a SLAPP suit, you're going to look at this statute and say, this case may be quickly dismissed, and my client may have to pay the other side's attorney's fees, which could be substantial. And the plaintiff's lawyer is going to tell his or her client that, and the plaintiff lawyer is going to say, you be careful about filing this thing if we can't allege claims that have any merit. That's the deterrent effect of this statute. It's real. And that's why the legislature can sensibly say that this statute prohibits SLAPP suits, because what it does is it forces plaintiffs' lawyers and their clients to make that calculation. But it doesn't create immunity. And the court already mentioned that 2 federal district courts, plus the Lamb case, both said that, all 3 of them said that this was a garden variety fee shifting statute. And that's the best interpretation of the statute. Indeed, 2 members of the Appellate Rules Committee, after they read our letter, flipped on this. And they said, actually, Mr. Esper's firm is right. This is, in fact, not a statute that grants immunity. And they did that because I think they took a fresh look at this statute and the arguments we made, and they said, in fact, it doesn't create immunity.
If you were going to direct us to one statute to look at as a counterpoint, one that does create an immunity or does create different evidentiary burdens as like a clear comparator to this, which one would you direct us to?
Well, I'm not sure, Your Honor, about evidentiary burdens, but in terms of immunity, I would direct you to 768.39 because it's in the same chapter. That's a great example of how even in this same chapter, when the Florida legislature wants to create immunity, they know how to do it. And they do it by express language. And that's how it should be, because the fact of the matter is saying that someone's immune from suit creates a whole bunch of consequences, including, obviously, immediate appeals that, as Your Honors had intimated, flip the normal burden in a case. Normally, your due process rights as a defendant is you got to take a shot with the trial judge and say this claim isn't pleaded properly, it has no merit. And if the trial judge disagrees with you and you have to then expend money on litigation, that's generally not considered an irreparable harm. It doesn't get you certiorari review. And that's the normal rule in litigation. That's the normal rule in litigation, not only in the courts of Florida, but all over the country.
Well, I mean, and plus, I mean, the whole concept of, I mean, you're immune from a meritless suit. I mean, that doesn't even make any sense. I mean, it just seems like they basically, especially when it's the government who's doing it, the legislature wants to penalize someone who brought something that wasn't just meritless, but also maybe was brought with some kind of improper motive or something. But just as a concept, the immunity thing just doesn't even really seem to fit.
I completely agree, Chief Justice Munoz. In fact, another reason why this statute can't create immunity is because immunity is normally class-based. So prosecutorial immunity. How do we determine if someone gets an immediate appeal? Well, we ask, are they a prosecutor? And if the answer is yes, they get to appeal. It's simple. Are you a government employee that can claim an immunity defense? Yes? Okay. Obviously, on my statute that I cited earlier, are you a school facing a claim regarding COVID relief? Yes? Okay. Immunity. But under this statute, any defendant can claim immunity. Any defendant can style their claim, their motion to dismiss, as an anti-SLAPP motion. What stops them? Certainly any case that involves any spoken or written words, the defendants can argue those words are protected by the First Amendment. Therefore, it's an anti-SLAPP motion. Therefore, I should get immediate appeal because I'm entitled to that immunity determination to be immediately determined by the Court of Appeal. I shouldn't have to wait. Immunity can't work with this statute. It doesn't make any sense. I do want to address this issue of the Keck factors because the other side brought up the Keck factors. The Keck factors, yes, it is true this statute does involve First Amendment rights. I do not in any way mean to devalue that. But there's two other things that this court should consider in that first prong of the Keck analysis. First of all, the fact that it doesn't create immunity. I think I've shown that in a number of ways. And secondly, that the rights of plaintiffs are also important. And remember, what's going to happen when you go up on interlocutory appeals, you're going to already have a ruling from a trial judge that whatever the speech is that is claimed is unprotected speech. So you're dealing with the right of plaintiffs to file cases alleging that unprotected speech has harmed them. Right now in another state, there's a case involving the Dominion people and Fox News, and they're suing Fox News for alleged defamation. And they just beat back a summary judgment attempt, and the whole point of their argument is they're saying that this was unprotected speech. Now, this was not speech that was protected by the First Amendment. These were just lies about Dominion. And based on that, they've won a ruling, an interlocutory ruling from the court over there. And the question is that don't the plaintiffs have rights and interests in that situation too, in bringing the case forward and making sure witnesses and evidence don't get lost, and not having their costs brought up with an appeal that could be completely meritless. Those interests count in the nature of the right too. The second issue under Keck is the likelihood of recurrence. First Amendment claims, unlike immunity claims involving sovereign immunity or prosecutors or whatever, these cases come with all sorts of different facts. There are millions of different fact patterns that raise First Amendment issues. There are different causes of action. One case might be a defamation case, another case might be an invasion of privacy case. There may be different legal tests involved. So the likelihood that the Court of Appeal can just take one of these cases and announce a rule that will apply to the class is very low. The third issue, resolution of factual issues, I think I've covered that. This statute calls for a determination as to what the intent was at the filing. That's a huge factual issue. That's the type of issue you want to have resolved at the end of the case. And finally, the fourth part of the Keck test, the increased workload. Every case that involves a written or spoken word, there's at least the possibility that some defendant is going to style their motion to dismiss or motion for summary judgment as a slap motion, and they're going to demand an immediate appeal. And indeed, if they're granted an immediate appeal under this rule change, that's going to encourage defendants to do that. And as a result, there's going to be a massive increase in workload for the appellate courts. So I don't think this works under the Keck test. I wanted to make one more observation about something my friend on the other side said, and that was analogizing this to injunction cases. This is not like injunctions, because appeals after injunctions involve a situation where there really is a right that everyone agrees about that's lost. If you win a case at the end of the case that establishes you had the right to do whatever it was you were doing, but all this time you were enjoined from doing it, that's an irreparable injury, that your damages don't solve that. So the whole point of taking up an injunction early is that it's restricting a litigant's freedom as an interim measure, and we go up on appeal and we decide that. That's, again, totally different than this. The injury that defendants are facing in these cases is just the injury of an ordinary litigant facing the ordinary costs of litigation because they were unable to prove to a trial judge that they were entitled to relief. The only workable approach to this statute, the only fair approach, is the one that's consistent with both what the legislature did do and what it didn't. It's to provide defendants exactly what the legislature gave them: expedited dismissal and fee shifting at the trial court, rather than an immunity that the legislature never granted them. We urge rejection of the proposed amendment.
Just a few brief points, if I may. I'd like to point out that the 4th District's articulation of the harm that the statute is designed to avoid. So the 4th District, in Materio, in which it said we're not going to use cert, but we think these are important rights, said the harm the statute seeks to prevent is the filing of the lawsuit for the purpose of suppressing the exercise of First Amendment rights. The longer such suits linger, the greater the expense and interruption of the lives of their targets. the greater the threat of financial liability, the greater the chill on the exercise of the constitutional rights. Forcing defendants to wait till the end of a factual inquiry at the end of the case renders those protections illusory because they have been chilled the entire duration of the litigation. And that is really the thrust of why the committee thinks that the rule amendment should be accepted. So the committee respectfully requests that the court would amend 9.130 to include review of these types of orders. Thank you very much.
Thank you. Okay, we'll now take up case number 22-741, City of Gulf Breeze versus Brown.
May it please the court and Mr. Levy. My name is Ed Fleming, and I'm here today with Ms. Lindsay Miller-Haley assisting, and we have the honor of representing the petitioner in this case, the City of Gulf Breeze. Thank you for accepting cert on this case. We understand you're a court of limited jurisdiction and that we do not have a matter of right to appeal this case. The court below considered it to be an issue of great public importance. This court agreed and granted cert. Thank you for doing that. The issue before you here today is not whether a spray field is a municipal use or a golf course is a recreational use. The issue is not whether those two properties continue to be used as a spray field and as a golf course before and after a private management company was hired. The issue is not whether a private management company, a private for-profit management company, destroys the immunity. The court below, in fact, the majority went to great lengths to correct the dissent in saying that's not what we're saying. We're not saying that the existence of a for-profit management company managing otherwise exempt uses defeats the immunity. So the issue today is very narrow, and that is whether the method of computing the profit for the for-profit company destroys immunity. And we would respectfully submit there's no precedent, no authority, no logic, no public policy that would support doing so.
Counsel, can we take it as a given, based on the record here, that there's no dispute that under this management agreement that the city was still ultimately in control of the use of the property? You know, the first DCA had the profit test. If we want to sort of clarify what is kind of the relevant consideration here, it seems like in terms of deciding who is quote unquote who's the exclusive user of the property, it seems like the control thing is a big part of it. Should we take it as kind of undisputed that the city is the one that controlled the property?
Yes, Your Honor, was undisputed. The depositions, the testimony by all of the witnesses, both before the Value Adjustment Board as well as before the Circuit Court, established that while the city personnel sat in the seats of the management office, that it was controlled by the Director of Recreations, Mr. Ron Pulley, I believe his name was, and that after the private management company took over, it was controlled by Ron Pulley. as Director of Recreation. It was control did not change, purpose did not change of the use of the property. The only thing that changed is you had a contract manager under a management agreement versus city employees sitting in the seats taking directions from the city as to how to use city-owned property for what everyone admits were municipal and public purposes, i.e. a spray field for disposal of groundwater from wastewater treatment area and for recreational use for the golf course.
I wonder if we could go to the text of the Constitution for a moment. So Section 3A says all property owned by a municipality and used exclusively by it for municipal or public purposes shall be exempt from taxation. Can you walk me through your reading of the words "and used exclusively by it for municipal or public purposes"? Clearly, your last answer says the control of the property didn't change. Did use of the property change in that a private entity, and let's leave aside that the mode of compensation for the private entity. Let's assume that is irrelevant to the analysis. If a private entity is also using the property to make a profit, how that squares with the text of the Constitution?
And, Your Honor, that is exactly the analysis. That's before you, of course. You look, as this court has pointed out many a time, you give effect to every word that's used in the Constitution. That was not done by the property appraiser in his briefing. I would note that no less than 6 times that phrase that you just quoted, used exclusively by it for municipal or public purposes, was cut off after the it. It didn't say for municipal or public purposes. And so it's used by the entity for municipal or public purposes. How did the city use the property? Not whether a third party may have benefited. You know, you could have vendors of golf balls who benefited. You could have a for-profit electrical company benefited from selling power to them. You could have someone who rented golf carts benefit.
Your reading of the Constitution then is as long as the city is using the property for municipal purposes only, then it is ad valorem exempt. So does that analysis cause the leasehold interest discussion to drop out of the equation, for example? Could, as long as the city is using the golf course for municipal purposes only, would it be free to enter into a lease agreement?
Your Honor, I think a lease agreement is analyzed under a different standard. And that's
why is that?
Well, because a lease gives a estate and property to another person. And so
if the vending machine company had a leasehold interest, then your position would be the golf course is no longer exclusively used by the city for municipal purposes.
No, Your Honor, because you can have ancillary uses. You can have a drink machine in a public park. It doesn't destroy the immunity for the public park because it's an ancillary use. You can have a pro shop that's supportive of a recreational golf course. It doesn't destroy immunity. You can have tennis pros at a city-owned.
Isn't the real question if this management agreement had been converted into a lease, and the same sorts of things are going on, but there's a leaseholder who has that possessory interest and all the other things that go with a leasehold. In that context, wouldn't it be your position that it really makes sense to say that the leaseholder is the entity that is using the property, as opposed to your circumstance where there is not a leasehold, but there's simply a management agreement in which it is the city that is using the property?
Precisely, Your Honor. When you give someone a lease to real property, you're basically saying you can act as the owner for this property, with the exception being your ownership expires at the end of the lease duration. So a lease completely changes the dynamics of this because a lease transfers a portion of the ownership, part of the bundle that we talk about in law school all the time. It gives part of that bundle of sticks to the tenant, and the tenant looks like the owner in many, many ways during the tenancy of the property. Here, that didn't occur Judge Makar in his dissent, and I understand it's a dissent, and of course a dissent isn't precedent, but they dissent when the court is being reviewed by Superior Court can be looked at and often becomes the majority opinion, if this court agrees.
That's what you're hoping for.
That's what I'm hoping for, Your Honor. I think the dissent, like all petitioners, I think the dissent was brilliant. and very well done. Justice Corral, you absolutely hit on the issue, is you have to look at the entire language, and it's the use by the city, the municipality, not the use by a third party that's important. Did the management company hope to make a profit through managing the property? Sure they did. But the control of the property remained with the city, and it was used for the very same purposes it was used when the property appraiser said it's exempt. It's exempt. So what changed? I mean, we talked to the deputy property appraiser and said, what changed? And he said, I don't know of anything that changed. They sprayed brown water on it before. They sprayed brown water on it now. They played golf on it before. They play golf on it now. It was under the control of the city before. It's under the control of the city now. So what changed? If the fact that a management company can make a profit doesn't alter the dynamics, and the majority below said
you would acknowledge that in some of the case law there is this talk about profit making, isn't there? That's a bad thing.
In some of the older cases there is. In the newer cases, it's the management companies are recognized as, sure, a private management company is going to be in the business of making a profit, and they can also have losses. So what did the majority say was differentiating? They said if you paid this management company a fixed fee and that their profit was determined by the difference between that fixed fee and their cost, that'd be okay. So, for example, if the fixed fee was $1 million, and their costs were $500,000, they'd have a $500,000 profit. But if you have a variable source of revenue, such as an encouragement to the management company to maximize the use of the golf course through green fees, a good thing for the public, maximizing the use of the recreation, then that defeats it. But neither one of those changed use by the municipality of the property. The use remained unchanged, and I think that is the critical point before the court.
Is it relevant at all that the management agreement purports to set out that the contractor shall pay any ad valorem taxes? Is that relevant to our analysis at all?
No, Your Honor. You cannot change by contract the Constitution of the state of Florida. The contract could have said this property is immune pursuant to Section 7.3a of the Florida Constitution. Would that have any effect? Zero. The city could have purchased an insurance policy from Lloyd's of London saying that if this property is ever taxed, you'll reimburse the taxes. Would that change the immunity analysis? Not at all. The rationale, the rule, and this court has held that unlike a lot of exemptions where the exemptions are not favored, they're strictly construed, the exemption for municipally owned property has just the reverse. It's presumed to exist, and it is the burden of the property appraiser to defeat that presumption. The rationale behind that rule is very simple, is that taxing government is bad policy. That issue was discussed in the case of Sorosa versus Micos, which was cited to in this court's decision. That cite came in the dissent, by the way. I point that out. But it was Florida Department of Revenue versus City of Gainesville. And why is that bad policy? Well, you shift the tax burden from the county. The county's taxes base would increase by taxing this property, and the city residents, their tax base would increase as a result of this. And that shifting, each side should pay their own taxes, and one government shouldn't tax another government. That's the philosophy behind that rule, that it is presumptively valid. Now, if the municipality goes and builds a hotel for profit, that defeats the immunity. Why? Because building a hotel is not a traditional municipal purpose, and making a profit from a hotel is not a public purpose of a municipality. That's the reason it's defeated. But it's been established, and it's not even disputed in this case, that operating a recreational golf course and operating a spray field for the environmentally sound disposal of groundwater are municipal purposes traditionally, such as the utility, and by case law, the operation of a recreational facility like a tennis court, like a golf course, and a marina are deemed to be a public purpose.
Can you help us though with the test? I mean, so I think we know from the sort of where this language in the 1968 Constitution came from, that there had been prior case law that said that a private entity could use its property for a municipal purpose, and it could things could be exempt. So that the Daytona Speedway thing. So then the language comes in and it says used exclusively by it. Right. And you've been kind of focusing on the municipal purpose part, which it really isn't the disputed part. What if you were how do you want us to articulate what the test is for when the property is used exclusively by it, i.e. by the municipality? Because we know it doesn't mean literally used exclusively by it, because the public comes and plays golf there. Sure. And whatever. Sure. So what is the test?
I think you would concentrate on ownership and control. Who owns the property? Who owns all the property? They haven't given part of their ownership away through a lease. And who controls the property? Is it owned by the municipality? Is it controlled by the municipality? And is that control exercised to accomplish the municipal purpose of a spray field, the public purpose of a recreational facility? I think that's the test, and that's a test. I think this court went to great lengths in the Treasure Coast case, going well beyond what you had to do, looking at case after case after case that have addressed this issue to try to provide some clear lines that property appraisers and municipal owners could follow. And I think those lines should stay where they are. I think the line of saying you have to look at how you have to look at how the profit is computed by a private management company to determine whether the use is exclusive or not is a fuzzy, inartful, difficult to follow test that, as the amicus said, would create chaos among the municipalities throughout the state if that rule is allowed to stand. Thank you.
Thank you, Your Honor. My name is Lauren Levy. I represent Greg Brown, who's a Santa Rosa County property appraiser. With me at the council table is Sidney Rodkey. If I could maybe start with the question that was last left with my friend Mr. Fleming. What was meant by the 1968 change? What should be the test? The test should be whenever government, cities, allows a private for-profit business to use city property for that purpose, you must lose the entitlement to the exemption. That is the exact and precise purpose that the 1968 Constitution was amended.
Well, but when you state it that way, you're assuming who is using the property. I mean, I guess that's kind of the core of the issue here, right? The question is the property being used by the city, or is it being used by the management company that the city has contracted with to help run the operation, subject to all sorts of restrictions in the oversight of the city? That's what this is about, right?
I think use ultimately comes down to what the court should look at as maybe opposed to control, Your Honor. But when the city says, I have an asset out here, here's a recreational asset. In Sebring, it was a raceway, which was a recreational asset. When the city says, I have an asset, and I'm going to allow you.
They leased it, and that's what we don't have here.
Your Honor, I realize we don't have a lease here. But
and throughout it, and am I correct in understanding? I mean, I understand you've got some some other things in the case law, but throughout the case law, the focus in these cases tends to be on the fact that there was a lease, and that is a recurring fact pattern in the case law. Isn't that correct?
Yes, Your Honor, and the reason why is because that's how cities interacted with entities that used their property. That was what was going on before the 1968 change. And if the Constitution were amended to say municipally owned property and used exclusively by it shall be exempt from taxation unless the property is leased, well, then we could draw the line at lease versus management agreement. But if I could continue just one moment. If this court were to draw the line at the distinction between a lease and a management agreement, you will eviscerate this constitutional protection, because no prudent city attorney will ever draft another agreement with a private user of government facilities as a lease. They will simply call it an operating agreement, and Article 7, Section 3 will have no more practical purpose or use. That's essentially is what they are urging. They essentially acknowledge, Your Honor, if we leased the property for running a golf course, it would be taxable. This court said so in Capital City. There's other appellate courts that said that. But because we didn't lease it, somehow the Constitution now must be read differently.
But what I'm struggling with here is just trying to draw this back to the words of the Constitution. Because when I look at it, property has to be owned by a municipality, and there's no question here that this is owned by the municipality. So this is all then goes to the phrase used exclusively by it for municipal or public purposes. And it just seems to me that in understanding that, we would ordinarily think of, when we think of a circumstance where there's a leasehold interest, we would think of the property that is subject to that leasehold interest as property that's being used by the leaseholder. Okay? I mean, that's just, but if it is property that is being operated pursuant to a management agreement, I think we would ordinarily think of that as property that is being used by the owner that happens to be subject to a management agreement. I mean, because that distinction between the lease and the management agreement seems to me to be quite material. It is a different sort of arrangement that affects the way we would think about who is actually using the property. What am I missing when I say that?
I believe it's a distinction without a difference. I believe the distinction between a management agreement and a lease is not mentioned in the Constitution and should not be the basis for distinguishing the private uses. In fact, when you look at this management agreement, Your Honor, what jumps out at you? Well, the entity that's being hired to manage this property is paying rent. They got all of the responsibilities that you would see in a triple net lease. They got to pay insurance. They got to pay taxes. I agree with counsel whether they got to pay taxes or not doesn't weigh in, but that's a typical earmark or hallmark, if you would, of a triple net lease. And so could you, as a city attorney, the document says lease at the top, you scratch through lease, you write management agreement, and all of a sudden now my property is no longer taxable.
Isn't your recourse in that case exactly what happened here? That is, you sue and you say this really is a lease, and a judge determines whether it is or it isn't a lease. And in this case, because inter alia, the document says on its face it's not a lease and no leasehold interest is transferred, you lost that argument, right? So it isn't this parade of horribles like, oh, we're never going to be able to tax anything because the city attorney is just going to scratch the name. That really doesn't hold up. You'd be able to establish if something was in fact a lease that was masquerading as something else. I mean, the courts aren't closed to that argument, are they?
Your Honor, I believe if you were to say in this case where the entity, the management company, is paying rent and has all of those other obligations, that form of an agreement still would allow the exemption. It would not destroy the exclusively by it. I'm not so sure there would be another management agreement that would fail that test.
I'm glad you've taken us back to exclusively by it, because of course that isn't the end of the sentence. And your friend made the point that in your briefing you sort of over and over and over again sort of omit the rest of the constitutional provision. And I'd like to sort of walk with you through the consequences of that choice. I mean, if your reading is correct, am I right that if if someone decided to hire a golf pro at this course to teach them the game of golf, that the property appraiser's position would be that the city has lost its constitutional exemption from ad valorem taxation because the golf course is now being used, at least for a moment, not exclusively by the city? So anytime a golf pro is hired, that's enough?
No, sir, I wouldn't believe so.
Help me understand why.
Sure. Let me try to distinguish this way. If the golf pro was given situs within the golf course, that is that's yours. You get to use that to do golf lessons, and nobody else gets to use it, and you get to keep whatever money you get from making those golf lessons. I would say that would be taxable if that were the case.
Okay,
We're setting aside.
So for you, it would have to be
area.
an exclusive agreement with a golf pro. But if there are 5 golf pros, then somehow magically the tax exemption is retained?
No, sir. I was trying to explain you would have an exclusive area for the use of that golf pro. Here, this company was allowed to use the golf course, the restaurant, the bar, the pro shop, all that, to generate business profits. It ran the entire course. No other entity was allowed to do the same.
Why should profit matter? Let's change the hypo. Let's say there's a charity tournament, a golf scramble, right? The whole course is available annually for this charity tournament. It is being used to raise money for the Gulf Breeze beach renovation project. And we have an agreement that every year, that weekend, the golf course will be used for that purpose, a beneficent purpose, a eleemosynary purpose. Are we now, is the tax exemption now gone?
No, sir, not on an infrequent basis like that, nor would it be if that was the only thing you could do at the golf course, because the Constitution allows the legislature to say such portions of property used for charitable, et cetera, purposes may be exempted, and you would be operating under that provision. And the reason, go back to the 1968 change, the reason I emphasize exclusively by it is because this court has said that is the significant language that changed in 1968. The municipal or public purpose definition did not change. That's the City of Gainesville case and the Treasure Coast case, which was actually a case that I handled. That definition has not changed. The 1885 Constitution just used the word exclusively. And when the change was made in 1968 to go to exclusively by it, this court, many times over.
But I insist, the rest of the sentence is still there, used by the city for a purpose, right?
I would agree. The rest of the sentence is still there, but that didn't change. The change was exclusively by it so that private users of governmental property are required to pay their fair share of ad valorem taxes. Look at it this way, and the court talks about it in Williams versus Jones and some of the subsequent cases. It's almost like an anti-competitive nature. Why should a business using government property to run its business and generate profits have an advantage over the business?
You keep assuming the whole what's in dispute. And everyone agrees that it doesn't literally mean used exclusively by it. And so we have to come up with some way of understanding what it means. But to get to your point about how everybody would just change the title of their agreement, are you suggesting that every government entity that was leasing over this property or changing the name to management agreement would want to take responsibility for the level of control over the use of the property and what goes on in a way that's present here? Because it seems like we're not just, the question isn't just what's the label on the top, it's the substantive content of the agreement. And I think that the suggestion is that if the city is the one that ultimately is controlling everything that's going on the property and saying how it can be used and this and that and whatever, and every time you want to change something you have to call someone in the city to get permission, that's what distinguishes it from the lease. It's the control factor, not what you call the agreement.
Your Honor, I believe that all governments if they're going to allow a private company to use their facilities, will want to have some level of control over what that person is doing, whether it's in the terms of a lease. You got to close the park at 10 o'clock, you can't stay open all night, or whether it's pursuant to the terms of a management agreement. All governments are going to have some level of control. What is the level of control here? This company runs the golf course, does the day-to-day operations, it provides a monthly report and an annual report, and the city maintains the right to utilize the irrigation equipment. But the record testimony in that regard was, well, the golf course superintendent determines how much water to put out on the course, and only if the pond is over 8.5 foot would we lean in and say we're going to have to put more water on the course than the golf course superintendent may deem necessary. But the testimony of that person, that's in the deposition of Mr. Prather, was that that had never happened in his time at the golf course. So the level of control that the city was exercising, I don't think it's fair to characterize it as they are there saying on a day-to-day basis what must be done. They required the contractor to have open records or open books, to provide those books to the city, the contractor to deal with customer complaints and various items like that. But when it got down to, well, how is this golf course going to be run on a day-to-day basis, that was the business of the contractor. I don't see where that level of control, Justice, is significantly different than a lease. I don't think a city would simply say, you have the right to lease this property and do anything with it at any hour of the day that you would so choose. And it's certainly not been an element that this court has looked at.
I mean, you're creating or projecting this idea that cities are always going to want to avoid anybody who leases property from them paying a tax, and therefore they're going to do this. Wouldn't there be circumstances, and aren't there circumstances, where a city says, we don't want to mess with this. We're leasing it, you deal with it, you pay the tax. Doesn't that happen?
I believe it does, Your
Okay,
Honor.
well, I would expect so, because they don't want to be involved in it. And so I think this kind of, the specter that you have suggested, I don't think always is going to be the case. And I'm just, and the idea that they're giving it to this management company to use, they have involved from another perspective, which is the city's perspective, is that they involve the management company to help them stop losing money, because they want somebody who knows how to operate it. And not somebody who's going to use it, but somebody who can operate it and reduce the losses that are being suffered. Isn't that another reasonable way of looking at it?
Justice Kennedy, if I may, that was the exact reason proffered in the Sebring Raceway case. The city had operated the Sebring Raceway for years and lost money. They continued to lose money. They wanted to bring in a prudent operator.
Well, and they leased it.
And they leased it, yes, sir. And their argument would be, if that were a management agreement, then this court should have reached a different decision. And I don't believe the Constitution should be read in such a fashion. It certainly is not evident in the language of the Constitution. And the courts...
But your friend answers that it is evident. It's evident in the first part of the provision. It's, in a limited sense, ownership has changed, right? You don't own all of the sticks in the bundle when you lease something. The tenant has, for example, a right of quiet enjoyment, all sorts of different rights that attach to a leasehold interest. And so maybe focusing less on the second part of the sentence and on the very beginning of the sentence, the argument would be that if I have transferred a leasehold interest, I don't own the property outright. I own it subject to that leasehold interest. Isn't that a way to square this court's jurisprudence on leases with the text of the Constitution?
Yes, but it would not be appropriate to say a management agreement is somehow different, Your Honor. It's basically the same thing. This company had the right to run this golf course and try to maximize profits as best as it saw capable of doing, Your Honor. It had the right to do that. No other company could do it. Nobody else could come in and say, well, I want to run it today. The city only could come in and do it if the contractor was not living up to its obligations. And in effect, the city had transferred part of its, if you want to say, bundle of rights. This was a 7-year deal with 2 5-year options that the city agreed. The city agreed that if we should sell it during that time period, you'll have the right of first refusal. And so you can make the decision whether you want to stay or not. And the city could not turn around and decide, well, we want to now lease it to somebody else under that. We don't have the ability to continue to run the golf course itself. And if the city could have run the golf course profitably, that would be profits that would go into the city's budget. So I don't see a material difference in characterizing the agreement with a private entity as a management agreement or an operating agreement or a lease, Your Honor. I don't believe it makes a constitutional difference. And if it were, then yes, we would look at, is this management agreement really a lease? And if this one is not, then none is.
It wouldn't be different if there was just a fixed fee for the management company? Say they're paid, X dollars a year, and that would that not change your view of the way this should be handled?
Your Honor, it certainly takes it a step away from acting more and functioning more like a lease, okay? Because a lease, you get to use the property to generate what profits you can. Here, the management agreement was the same. And I think the First District Court, when they pointed that out, they were trying to answer just the question, and as much of the question in front of them as they needed to. I'm the practitioner in this area. I would like the court to say it doesn't matter whether the use is pursuant to a lease or a management agreement. That's a more expansive decision. It functions a lot.
Well, you're representing Mr. Brown. I understand.
Right. Well, it functions.
Mr. Brown's won a few of these cases, right?
Yes, sir. He certainly has, and my office has been involved in a lot of other cases in this area. And it does appear to us, when you look at the history of how we got to where we were at, that the Constitution was changed intentionally in 1968 so that private operators on government property should have to pay ad valorem taxes just like the folks they compete with. If I could make one final comment.
Well, let me ask you, though, just to close the loop here. So you think that the earlier first DCA case that it said that the flat fee management agreement didn't change the tax status, was that wrong?
I'm sorry, I didn't quite follow you.
Wasn't there an earlier case where there was a flat fee and the court said that didn't? That didn't affect the tax exemption, and now the first DCA seemed to think that the changing the nature of the compensation was relevant to the tax status. Do you disagree with that?
So in Zengali, the First District Court pointed out that the golf course was operated for a nonprofit basis, and there was a management company involved in there, but this court didn't look at that on appeal, and it didn't approve it in the Treasure Coast decision. And if I could just have one second, please, Your Honor. The 1968 change seems like that's a long time ago. In 1978 and 1998, the voters of the state of Florida were asked to amend this very provision and amend it in a way that would allow the exemption under these circumstances. And the voters both times voted it down. This court in Sebring acknowledged that that was the paramount public purpose that we should be looking at, and we would ask that you affirm the District Court of Appeals decision and answer the certified question in the negative. Thank you very much.
Used by and managed by are different terms. Every private management company could be deemed to use whatever property they're managed. They could be deemed to use it. If that destroys the immunity, then it's destroyed for all private management companies. As the League of Cities points out in their amicus brief, is that hiring professionals to manage city services is a growing trend. Why? because professionals managing services tend to do a better job. What do the facts in this case show? The city managing these properties with its own staff lost money year after year after year. Their primary goal was to stop losing money. They wrote this management agreement very favorable to the taxpayers of Gulf Breeze. I'm not sure I would have signed it if I'd been the management company or recommended it if I'd been the lawyer, but very favorable to the taxpayers that stopped the losses. The management company did exactly what the city told it to do, what the city wanted it to do, and the uses of the properties remained unchanged. The only thing that changed is the city wasn't losing money every year in the management of these companies. So do we want to discourage that as a matter of public policy? I would think not. I would think that's an issue that we don't want to discourage, and no court has done that. No court has done that.
You know, there was something I meant to ask you earlier and failed to. The golf course is outside municipal lines, is that right? It's not
That
in
is
the
correct.
city. Is there any relevance to that fact given the second sentence of Section A to our analysis, or is that just not at issue here because there isn't a general law requiring taxation on the property?
It's not an issue, and the courts have looked at the fact that, for instance, transmission lines conveying electricity may be on property that's not owned by the governmental entity that's providing the power, but that doesn't matter. It's how the property is being used. In this particular case, you know, the facts show that before the city even purchased this property, it was using it as a spray field. The facts show that when they were using it as a spray field, they were constantly having a fight with the golf course because the golf course saying, our fields are saturated. It's been raining a lot, and therefore don't put any more groundwater on our fields. We have to. We don't have anything else to do with it. We have to do that. And so there was constant battle. So when the golf course came up for sale, the city said, we need it for our groundwater spray field. Let's buy it. Was there intent to make a profit? No. Was there intent for the management company to make a profit? No. Their intent was to have a reliable place to dispose of their groundwater and the ancillary use of recreation for the citizens. In the case where a marina is used by both residents of the jurisdiction and non-residents of the jurisdiction, is still deemed to be a public purpose. So there was no question in this case, Your Honor, that the use of this property for a golf course was a public purpose. The court below said that, and the property appraiser never challenged that. In fact, the property appraiser year after year after year granted the immunity for this property based on the provision of the Constitution granting immunity, and it changed it when and only when there was a management agreement, which it claimed was in reality a lease. The argument that everyone would just change the names on leases to management agreement is disingenuous for the simple reason that the court can look to the form of a document. In fact, a case that Mr. Brown successfully handled before this court was the Navarre Beach tax cases in which the documents were called leases. But this court found that they were, because they were perpetual leases, actually conveyances, because the property never came back to the owner, who was a county who was immune from ad valorem taxation. Thank you.
Thank you. We're going to take a short break, and we'll be back for the last two cases.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
Welcome back. Our next case is number 21-1580, Ellison versus Willoughby.
Thank you, Your Honor. May it please the court, I'm Paul Nettleton with Carlton Fields. I'm here with my partner, Jeffrey Cohen, and we are representing the petitioner, Alberta Ellison. Your Honors, we're here today on a certified question from the Second District, which effectively asks, was Ms. Ellison entitled to a set-off for a $4 million settlement that the plaintiff in this case entered with his uninsured motorist carrier in this auto accident case. Initially, the Second District agreed with our position that the plain text of 768.041 required a set-off here, but then went on to find that precedents from this court required it to ignore that language. And because Ms. Ellison and the UM carrier, 21st Century here, were not joint tortfeasors being sued on the same claim with the identical elements of damages between the claims. And this, despite the fact that the settlement agreement compensated the plaintiff for the same damages that Ms. Ellison was being sued for, and that is the damages, the injuries and damages caused by the crash. Before I get into the details of that issue, Your Honor, I would just like to point out that we also raised two other issues outside the certified question in our brief that we hope the court will look at as well. The first is whether Mrs. Ellison was entitled to application of the vicarious liability statutory cap in 324.021. And we submit she was, and we'd ask the court to take a look at that question, specifically the certified question that was presented in the Ortiz case, an earlier case from the Second District, which never made it to this court. And we submit that the fact that they were co-owners between the driver and Ms. Ellison should not make a difference to that application of that statute.
I'm sorry to interrupt you. Before you get into the merits, I want to make sure that you have an opportunity to address the preservation issue as it relates to 768.041. Looking at the record, it seems like every time that your client raised the set-off issue in front of the trial court, and this was multiple times before trial, after trial, at a hearing, it explicitly invoked 768.76 rather than the .41 or 041. They're obviously very substantively very different arguments. I understand that some of the cases that were read and relied on invoked both, but it doesn't seem like the trial court really had the .41 issue before it. Could you address that?
Yes, Your Honor. Actually, I think it did, and I agree. The trial counsel did not cite the 768.041 either in the arguments or in the papers. However, the substance of the argument under that section was, in fact, addressed by counsel in the trial court. Specifically, it was presented by virtue of the motion, although citing the different statute. The motion said that they were getting a double recovery here, that the damages were the same, and that therefore, under the law, there should be a set-off here. And
what's your best case for the proposition that if the substance of an argument is before us, and yet it has not been specifically and expressly invoked, that we nonetheless find that it has been preserved? Because I don't think that's the state of our law.
Well, Your Honor, in Williams versus State, which was from this case, it was preserved by presenting the legal principle to the trial court, although the defendant did not cite any specific statute.
Got anything not involving a criminal case?
Yes, Your Honor. Wilson versus West American Insurance, that's a 4th District case. In that case, the appellant was requesting costs as a prevailing party, and the appellee was arguing that wasn't preserved because they cited the wrong statute for the costs in their motion. And the court said, no, that doesn't get you there. They presented the argument to the court, and they're entitled to proceed with that. And the 2nd District did address this in the opinion and found that it was adequately preserved. And I'd refer the court specifically to the transcript of the post-trial hearing on this, where counsel argued to the court, and it's at the supplemental record at 17-275 and 76, where he made the very substance of the argument under 768.041, although he didn't cite the statute, that this was a double dip, that the plaintiff had recovered the same damages under this settlement agreement that he had recovered against Ms. Ellison in the case, and that therefore the law required that there be a set-off here. And that's what we're arguing.
But counsel, isn't the test of, this preservation requirement is about making sure that the trial court has really had an opportunity to address the issue, that it's been brought to the trial court's attention in a way that would enable the trial court to properly apply the law. And in this context, you've got these kind of complicated statutory schemes where you've got to kind of wind your way through the statutes and see if you can check this box and check the next box, see if it is actually covered. We don't just have a general principle of no double dipping, okay? That's not a general principle. Maybe it should be, but that's not what we've got. It's got to fall within the provisions of the statute. It's just I'm having a hard time seeing how, based on what I've seen here, we could say that the trial court was adequately appraised of the issue so that the trial court could deal with it properly.
Yes, Your Honor. Again, we argue the very principle that we're arguing here under the statute. The trial court went off on this benefits issue, which didn't even address it under 768.76. But I'd also point out that the plaintiffs were aware that this was in play because they specifically addressed it in their response to the motion in the post-trial briefings. And specifically, that's at page 3168 of the record. They specifically addressed 768.041, argued that we could not get the settlement set off under that because they weren't joint tortfeasors, citing Gowdy, the very things that they argued in the 2nd District, very things they're arguing here.
Yeah, but you were the one asking for the relief, and every time when it was brought up by the other side, you immediately went back to the 768.76. I mean, I don't mean you personally, but your side. So, you know, the court, and they're very different. You know, the double dipping thing is the same rationale maybe for both, but it really, it doesn't seem like the court would have had any I mean, the court would have had to basically go and kind of do its own homework and make your argument for you to give you relief under the .041 statute, it seems.
Well, Your Honor, again, I would say, as you mentioned already, the cases that were being cited did refer to all of the statutes. Counsel for the plaintiff understood that we were arguing essentially under all of the statutes. And the principle of no double dipping, it's the same damages that are being recovered in the settlement agreement as well as against Ms. Ellison in the verdict, was argued. And so we submit that under the case law, that's sufficient to preserve the issue. So, Your Honor, if I could get into the merits of the certified question here. I've kind of already talked a little bit about it, but the fact is that the plaintiff sued his carrier, 21st Century here, for bad faith, and as part of that claim specifically requested recovery for the damages that were caused by the crash. During the course of the litigation, that was settled for $4 million, and the second district initially said that it would seem that under the plain language of the statute, the set-off statute, 768.041, that a set-off would be appropriate. And what it said is the plain and unambiguous text, and I quote, required the trial court to set off the 21st century settlement proceeds because Mrs. Ellison showed that Mr. Willoughby delivered a release to 21st century in partial satisfaction of the damages he sued for in this lawsuit. Now, despite that recognition, the court went on to say, no, but the Supreme Court in these trilogy of 768.81 cases has said you don't get a set-off unless you're jointly liable for the same claim with identical elements of damages. But in those cases, what this court was doing was determining how do the set-off statutes apply in a joint and several scenario where we have 768.81, which has eliminated joint and several liability. And the way the court analyzed 768.81 was that it found that joint tortfeasors are now liable only for the damages they cause and not for the damages of the other joint tortfeasors. So as a result of that analysis, the court held that the set-off statutes no longer apply between joint tortfeasors to the extent joint and several liability is eliminated because the settlement amount paid by the settling defendant could not be the same damages for the non-settling tortfeasor. So, and I would submit, if there's one thing everyone agrees with in this case, it is that Mrs. Ellison and 21st Century were not joint tortfeasors. And so 768.81 has no application in this case, and for the same reason, Wells, Gowdy, and D'Angelo, the three Supreme Court cases at issue, have no application here. In those cases, the the defendants, the settling and non-settling defendants, were joint tortfeasors, but they were not sued for the same damages based on the application of 768.81 as interpreted by this court initially in Wells, and I would say also probably in Fabre. In this case, however, Mrs. Ellison and 21st Century were not joint tortfeasors, but were sued for the same damages. And this court, I would submit, in the trilogy of cases we're talking about, did not hold, as the second district believed, that a set-off is only available under the statute for joint tortfeasors sued on the same claim. Certainly there's nothing in the statute itself that limits it to joint tortfeasors sued on the same claim. Rather, the focus, as it's always been and still is it the same damages?
Can I ask you about the broader context?
I'm sorry?
Could I ask you about the broader context of the statute? So Section 1 talks about the release or discharge the liability of any other tortfeasor who may be liable for the same tort or death. And then in the title for this bill, when it became law, it says an act to permit the releasing of one tortfeasor without its effect being to release all tortfeasors and providing for set-off in actions against other tortfeasors. So it seems like there's more. The whole idea that if I just read the words of Section 2 in isolation, that tells me kind of the plain meaning of that. It seems like if I read this whole thing, it's not as clear as what you're suggesting. That even if we assume that it's the same damages, which is obviously in dispute since the nature of the bad faith thing is different, but it seems like if we read the whole thing, it's not clear that the only relevant question is the damages aspect.
Well, Your Honor, subsection 1 of the set-off statute deals with a different really issue, and that is if you release one tortfeasor, does it release other tortfeasors? And the statute was put in place for that section to say no, it does not. I don't think you can read that particular language, and it's not just joint tortfeasors, it's any tortfeasors. It wouldn't release them because I think there was some prior law that suggested if you released a joint tortfeasor that somehow that could release the other joint tortfeasors. And the legislature in subsection 1 was addressing that to avoid that situation. In subsection 2, though, there's no reference to joint tortfeasors at all. And I would submit that certainly the legislature could have put it in there if that's what they meant, but it's not there. It says any party who shows that it's the same damages is entitled to that set-off. So we think it's very clear that you don't have to be a joint tortfeasor. I'd refer the court to the Grobman versus Posey case out of the 4th District, which extensively addressed this very issue. And it looked at Wells, Gowdy, D'Angelo, 768.81, the set-off statutes, and concluded that where you are not joint tortfeasors, that trilogy of cases and 768.81 do not apply at all, and you look solely at the set-off statute itself for determining whether or not the non-settling defendant is entitled to a set-off. And in that case, the court found that, yes, the non-settling defendant who was not a joint tortfeasor was entitled to a set-off for the entire amount of the settlement because it was undifferentiated.
Counsel, I'm looking at this statute here and your argument that we look at subsection 2 in isolation. I'm just struggling with that because it's central to subsection 2 is the delivery of a release or covenant not to sue, right?
Correct.
Well, that seems to take you right back to the first word of subsection 1, a release or covenant not to sue. So when we're looking at that phrase in the context of subsection 2, I don't know why we wouldn't look back to subsection 1 to see what they're talking about when they start off talking about a release or covenant not to sue. I'm not, you see what I'm saying?
No, I understand, Your Honor, but a release is a concept, or a covenant not to sue is a concept. I don't think it's tied to any particular.
Well, but it's in this context here. When they're talking about it, it just seems to be you've got to look at the way they've talked about a release or covenant not to sue. That's what they're referring to. And then when it's a release or covenant not to sue as to one tortfeasor, and then the reference to any other tortfeasor, I just don't see how you can read that subsequent reference to that same phrase in a way that is divorced from the way it is used in the preceding section.
Well, Your Honor, again, I disagree with that respectfully, but if they wanted to apply subsection 2 to only joint tortfeasors, it could have said that. It does not say that. It says any defendant shows that a plaintiff gave a release in partial satisfaction of the damages sued for, they're entitled to a set-off. That's how it reads. It doesn't limit it to joint tortfeasors. Grobman versus Posey made that determination. The 3rd District, actually a few years before that, in J.R. Brooks versus and Sons, made the same determination, saying 768.81 and Wells do not apply, and therefore if you're not joint tortfeasors, you just look to the set-off statutes, and if it applies, and you get the set-off. So we would submit that's the situation here. Now,
can I ask you though, you started to talk about the issue of an undifferentiated settlement, the whole thing goes out. Is that textual? I mean, it seems like here it does put the obligation on the defendant to show that it's partial satisfaction, and it says set off such amount, meaning the amount that's in partial satisfaction of the damages sued for. We know that here the settlement it's undifferentiated, but it could have included all kinds of other categories of damages that wouldn't be the same here. So why isn't the burden on the defendant to show what in the settlement was, corresponds to the damages sued for?
Okay, well, Your Honor, there's a couple of things here. First, we look at the settlement itself. And the settlement itself specifically says that the plaintiff in the 21st century agreed that all sums set forth herein constitute damages on account of personal injuries or sickness. For only personal injuries or sickness are the ones caused in the accident, which is what Ms. Ellison was sued for. And then even if you ignore that language in the settlement itself and assume there were some other elements of damages from the bad faith that could not be sued against the tortfeasor, it still doesn't get you out of the situation here because it's undifferentiated. It's undisputed here there was no allocation of the $4 million between claims, elements of damages, and so forth. So that calls into place the rule that this court established in Dionese versus West Palm Beach. And in that case, the court held where there are elements or claims or damages that are subject to set off and other claims or damages that are not subject to set off included in a settlement agreement, unless that settlement agreement itself expressly allocates between those elements, that the entire amount of the set off.
What about, well, my question was whether that's text-based, but also, we also said right after we talked about the undifferentiated rule, we said, if necessary, the settlement can then be allocated proportionally against the jury verdict for each cause of action tried, thus preserving the distinct nature of the separate claims. Which would suggest that here you would get nothing, since obviously the bad faith claim and the tort claim are two totally different claims.
They were totally different claims, but for the same damages as set forth in the settlement itself. But and if the bad faith claim had been tried, then you could have perhaps done that allocation according to whatever the jury verdict was. But we don't get to that point because there was a settlement, and that's why in Dianese, this court said, you get the entire amount of the settlement where it's not allocated. If they had allocated between personal injuries recoverable under the statute and the bad faith claim, that might be a different scenario here, but they didn't do that. And they are the same damages. I'm sorry.
Sorry, you can have a couple of minutes to address the.
I'm sorry, Your Honor. I didn't realize I was over. Thank you.
No. Go. Just whatever. If you can take a couple of minutes on 768.76, so that your colleague here can have something to respond to on the other, since that's obviously another.
I'm sorry, Your Honor. So, are you talking about the statutory cap issue?
No, the 768.76, the second half of the certified question.
Your Honor, we would rely on the brief for that. We think, arguably, it fits within the contract plan or agreements that are set forth there, but we think it's crystal clear under the other statute.
Okay, you can have 2 minutes for rebuttal.
Thank you, Your Honor.
May it please the Court. My name is Brent Steinberg, and it's my privilege to represent the plaintiff, Randy Willoughby. Your Honors, this Court should affirm because the trial court properly denied defendant's motion for set-off. First of all, as Your Honors alluded to, in the trial court, the defendant never argued that 768.041 entitled them to a set-off, so that issue hasn't been preserved. But even if it was preserved, under this Court's precedent, it doesn't apply because defendant and 21st Century, the uninsured motorist carrier, were not jointly liable for the same damages. And defendant's also not entitled to a set-off under 768.76, which is the collateral source statute. Quite simply, the uninsured motorist bad faith claim settlement doesn't qualify as a collateral source, and we briefed that fully. I won't get into that issue unless one of Your Honors has a question on it. So let me first address this preservation issue, and there's really two separate preservation issues here. The first is, as we said, that the defendant never argued that they were entitled to a set-off under 041 in the trial court. There's no question that they asked for a set-off, but they only ever characterized it as asking for a set-off because it was a collateral source. And that's kind of like saying that someone objects to evidence coming in because it's hearsay, and later they want to argue that it was inadmissible for a different reason under 9403. All the courts would say, yes, you asked for the right relief, the ultimate relief of keeping the evidence out, but the hearsay objection doesn't preserve the 9403 objection. That's essentially the situation that we have here. They didn't just fail to cite the correct statute, they never made the argument at all that there was a release that was delivered in partial satisfaction of the damages sued for. So they never made the argument until they got to the Second District Court of Appeals in the initial brief. Now, the second preservation issue is in the plain language of the text itself, in 768.041, subsection 2. As Your Honors alluded to, looking at that language, it says, at trial. At trial, if the defendant shows that shows the court, the statute says, that if they show the court that the plaintiff delivered a release to a person, then they get a partial satisfaction, and that it was in partial satisfaction of the same damages sued for, then they get a set-off to that extent. Again, in the trial court, defendant never argued that she was entitled to a set-off, making that argument. So the first time that they argue 041 is in the appellate court. That is not at trial. That is not never at the trial court. Of course, it's our appellate court's job to correct errors that trial courts make. And Your Honors alluded to the case law, and we cited several cases for the proposition that the trial court has to be given a fair and full opportunity to address the issue head on. How are we going to say that the trial court committed reversible error by failing to grant a set-off under 768-041 when the defense never asked the trial court to do that? So in our view, the issue has not been preserved. There's no need for you to get to the merits on 041. If you do want to get to the merits, we still prevail. And I want to clarify one thing. There was some discussion about the joint tortfeasor, and certainly the cases that this court has previously talked about was in the context of joint tortfeasors. But I think what's more important than even joint tortfeasors is whether or not there's joint liability. Now, of course, if they're joint tortfeasors, they would be jointly liable for the same damages. But I acknowledge in the Grobman situation, where you've got a vicariously liable party, it would make sense to apply the set-off even if they're not technically joint tortfeasors. For instance, if you have an employer who settles a claim, the employee, assuming it was vicarious liability, would get a set-off if the defense makes the requisite showing under the statute. So the court's focus in all of those cases is really, has there been joint liability for the same damages? Before we get more into the weeds on that.
Well, the precise language is may be liable for the same tort or death, right?
Under subsection 1, Your Honor?
Yes.
Yes. That's correct. And in the vicarious liability situation, which this is not a vicarious liability situation, we've got two separate silos here. We've got an uninsured motorist carrier on one side and a tortfeasor on the other. It's not vicarious liability, but when you're in the same silo, it would make sense that the employer is vicariously liable for the same tort or death as the employee who caused it. And that's why in Grobman there was a set-off, which is a DCA case. But stepping back, let's just think about what it is that they're asking for. And I want you to assume that we're not talking about a $30 million verdict. Say it was $3 million. And the plaintiff had already settled their uninsured motorist bad faith claim for $4 million. In that situation, would the defendant get a set-off for the entire amount and be able to tax costs against the plaintiff and perhaps even recover attorney's fees just because there was a separate settlement with an uninsured motorist carrier for $4 million when they in fact caused $3 million of damages? That wouldn't seem fair and equitable. It would be a massive windfall to the defendant in that situation. Well, that's essentially the situation we have here.
I understand what you're saying, but on the other hand, what's happening in the claim against the uninsured motorist carrier is obviously in some sense derivative of what has happened in the context of the case against by the plaintiff against a tortfeasor. And this is not really an issue here, but let me ask you, help me understand the rationale behind the legislative policy that awards, that authorizes a bad faith claim against uninsured motorist that goes beyond the actual amount of any kind of damages that were attributable to the failure to pay the uninsured motorist claim. Sure. I mean, it's very different than an ordinary uninsured, bad faith claim where there's the risk because the carrier failed to settle that the policyholder is going to be exposed to damages that exceed the amount of the coverage. But I'm trying to understand how that gets translated over into the uninsured motorist context.
Sure, and certainly to some extent I agree with Your Honor that the damages that are recoverable are derivative, but it is a separate claim. But to your question, and this is outside the briefs, but let me just to try to address your question. So Under the common law since 1938, we had third-party bad faith claims, and we never had first-party bad faith claims. That didn't come until 1982 when the legislature passed the 624-155. And there was a Supreme Court case called McLeod, which said essentially that the damages that were recoverable in that case, if the uninsured motorist carrier acted in bad faith, were only essentially the consequential damages. And it was a couple years after McLeod, maybe even the next year, the legislature essentially overrode McLeod by passing subsection 10 of the uninsured motorist statute, which says that the damages shall include not only the damages caused by the uninsured motorist carrier and their failure to settle, but also the damages caused by the tortfeasor. And this body has said that that was in effect a penalty. It was most recently in the Fridman decision said that it was a penalty for the wrongful failure to settle. So that was the legislative's intent behind that. It was essentially to override the McLeod decision and to make sure that there were some teeth, because sometimes there aren't any consequential damages caused by the bad faith failure to settle, but the legislature wanted the UM carrier to pay the damages that were caused if it is found that they violated 624-155-1B1 by failing to attempt to settle in good faith. And here there was we alleged a wrongful denial of coverage, and that was what was the genesis of that claim. But back to the 041 argument, so the focus has always been, and it actually started in the Delvin decision, and then went on in Reimer and Wells and Gowdy and D'Angelo. And all of 5 of those cases, the court was always focused on, was there joint liability for the same damages? Essentially, that is what the court interpreted impartial satisfaction of the damages sued for means, which makes sense. If it's going to be a partial satisfaction, given there had to be some sort of joint liability there, and there had to be the same damages. And I apologize, Your Honor. It seemed from the briefing at least that the defense agreed with me on that point, and that our dispute was essentially over whether there was joint liability and whether or not the damages are the same. But back to Justice Kennedy, your question about the legislative intent, the UM bad faith statutes make clear that the UM carrier shouldn't get a set-off for an amount paid by the underinsured tortfeasor. We have 155-1B1 that says when they fail to attempt to settle in good faith, that they'll be liable for the damages as provided by statute. Subsection 4 says that they shall be liable for the damages plus fees and costs. And then subsection 10, as we said, says that those damages shall include the total amount of the damages, whether caused by the tortfeasor or the UM carrier. And if we look at the shalls, the UM carrier shall be liable for those damages, and we understand the penal purpose behind it, then it would make sense that the UM carrier wouldn't get to offset its own liability in UM bad faith for some amount paid by the tortfeasor. And that brings us squarely within this court's Wells decision, because that would mean that they were only severally liable. They weren't jointly and severally liable. They were only severally liable for the damages, meaning that 768-041 should not apply. The damages, as Your Honor alluded to, were not identical either. They're not the same damages. They're two, one is a statutory penalty, and it is true that when you're calculating the amounts of that penalty, you do understand and consider the underlying personal injury damages. But there are other buckets of damages. There's attorney's fees and costs, pre- and post-judgment interest, consequential damages, perhaps even punitive damages. And Mrs. Ellison would never be liable for any of those. So the damages aren't the same either. And we cited multiple cases which held that a set-off under 041 is not appropriate when the damages, although maybe overlapping, were not coextensive. The damages have to be identical. So if they're overlapping, but they're not the same damages, then they don't get a set-off. Now, if you disagree with me both on the points of joint liability and the damages being the same, then we get to the apportionment question and the Dionese case. And first of all, just to clarify, excuse me, Dionese was a case against joint tortfeasors. So there is no question that there was joint liability, and which is unlike the situation where the uninsured motorist carrier should never be jointly liable with the tortfeasor. But Dionese is also distinguishable. it was a case about two plaintiffs. There was a husband and a wife. The wife had a claim for her injuries, and the husband had a consortium claim. And what happened there is they settled with one defendant, and then they allegedly made a secret agreement among themselves on how to divvy up the money to maximize their recovery from the remaining defendant at trial. And the court says that that's not binding. The settling defendant wasn't part of that agreement, and the secret allocation shouldn't be binding on the non-settling party, and that wouldn't be fair. So what the court did there is they allocated the award proportionally, meaning that, for instance, if the wife had $90,000 in damages and the husband had 10, then the first settlement should have also been split 90-10. The Wells decision, much later, the court said it would invite collusion to allow the settling parties to control the allocation between different elements of damages. That is more akin to the situation we have here. And I'm paraphrasing what the court said in Wells, but the court said that the plaintiff would seek to maximize the amount of their settlement apportioned to the claim where there's no joint liability, and it would make no difference to the settling defendant who's getting out of the case, so they would be more likely to be amenable to that allocation that's proposed. And perhaps they would even be able to settle the case or save some money on the settlement if they agreed to the plaintiff's proposed allocation. And all that makes sense, and that's why the allocation isn't binding.
It would be a sham allocation.
It could be. Right. It could be. Let's play that out. Let's say that I had an agreement with 21st Century that all $4 million would be allocated to attorney's fees, interest, and punitive damages, none of which is recoverable from Ms. Ellison, so there'd never be joint liability for that. Why would it be fair to say that Ms. Ellison would be bound to that allocation, even if it appeared on the face of the settlement agreement itself? It wouldn't be fair. She didn't have the opportunity to object. She wasn't a participant in that settlement agreement. So if the allocation agreement, if we had one, wouldn't be binding on Ms. Ellison, then why should she get an automatic set-off for the full amount just because we didn't have an allocation agreement? That doesn't make sense. Particularly if you look back at the statutory text, it says at trial, if any defendant shows the court, the burden is on the defendant there. I don't, as a plaintiff, have to do anything. The defendant has to make the showing. They have to ask the trial judge or perhaps even the jury in a bifurcated proceeding to determine the extent of the overlap. If, in fact, there was joint liability, and if you get past the joint liability and determine that at least some of the damages were the same, that is what the defendant's burden was. And they simply didn't meet that burden because they never even asked for a set-off under 768-041 in the trial court. So they didn't meet their burden of proving a duplication, meaning that the trial court was entirely correct to deny set-off. On 768-76, if the court is applying the supremacy of the text principles, it is looking at the text, what is written on the page. It is not accepting the defendant's invitation to try to apply some broader intent to prevent double recoveries. Of course, the statutes don't say anytime there's a double recovery that the defendant gets a set-off. We have to apply the text as it's written. And the legislator hasn't defined a collateral source to cover an uninsured motorist bad faith settlement. They claim in the briefs under three separate provisions. First is subsection 2A2, where they say that certain types of insurance benefits are collateral sources. Not all insurance benefits, just certain types. And the defendant argues that 2A2 applies because the settlement was derived from the plaintiff's uninsured motorist policy. Well, the word derived doesn't appear in the statute. The question isn't whether the settlement was derived from an insurance benefit which is recoverable. The question is whether or not the payment was an insurance benefit. And this, by definition, is not an insurance benefit. It is a statutory penalty over and above what they owed under the policy. It is extra contractual damages. So 2A2 does not apply. 2A3 is about payments to pay medical service or agreement to pay medical services. And 2A4 is an agreement to provide disability benefits. And our settlement with 21st Century was neither of those. 21st Century didn't agree to pay medical benefits. They didn't agree to pay disability benefits. They would never be liable for essentially health insurance or disability insurance. Now, it's true that the plaintiff could use some of that money that he recovered to pay his own medical expenses, or perhaps he could have paid his own or compensated him for his lost wages. But 21st Century didn't agree to pay that, and there's no reading of the text where you can say that an uninsured motorist bad faith settlement qualifies as a collateral source.
Is
So
your
that doesn't apply.
argument on that, though, to defeat the, I mean, there's a sense in which part of the argument is this is just completely kind of categorically talking about different things, but to the extent that you're literally, that you're responding to this kind of literal argument that it was a, it was an agreement and it was, the damages included medical expenses, is it just the fact that the settlement agreement itself doesn't say we're going to pay you $4 million, including $1 million for past medicals? I mean, would that fit it within the statute, or how much of the argument hinges on the absence of those specific words in the agreement?
I think it's important to remember the claim being settled, not so much dictated by what the settlement agreement said, but the claim was for uninsured motorist benefits and uninsured motorist bad faith. And the UN benefits aren't recoverable, and that's not even an issue which is before the court, but there's a contractual right of subrogation in a UN policy, which under subsection 1 means that they don't get a set-off because of the subrogation right, even if it did qualify as a collateral source. So we're talking about the UN bad faith damages, and the payment was just not a reimbursement or a payment of medical expenses. And just to clarify, when we say that something is on account of a personal physical injury, which is put in there for tax purposes, that is not the same thing as saying it is a payment of a medical expense. It was a settlement of a disputed claim for violation of 624, 155, 1B1. So if you had that type of broad reading, then you could say that any settlement could, if it was later used to pay medical expenses, would qualify as a collateral source. And of course, our common law collateral source rule still exists, and the statute overrides the common law, and the courts always have said that we will not read the statute to override the common law unless that change has been effected with clarity. And this does not clearly override the collateral source common law rule in this situation. So
you can have 30 seconds to finish up.
Well, for those reasons, I guess, Your Honors, we'd ask that you'd affirm. Unless one of you have additional questions, I'd be happy to answer. Okay. Thank you very much.
Thank you, Your Honor. First of all, on the preservation issue, I'd point out on the motion to determine collateral source set-off, which was filed prior to trial, it specifically says that 21st Century settled with the plaintiff for a total of $4 million pursuant to the settlement agreement and release, which is attached to this motion, and that all the monies concerned in the settlement agreement, including all bad faith damages, constitute damages on account of personal injuries sustained by plaintiff in the motor vehicle accident at issue. The same damages sought against Ms. Ellison. That's exactly the argument under 768.041. In the transcript, it says the argument is simply, this is defense counsel, Your Honor, is that the same damages that were paid for the same. It's a double dip, as I said. We can tell, and says we can't find any case law on this because there was no case law. We can tell you what we believe is right. It was for the personal injuries that he received in this case and therefore should be set off under the law. That's the argument. Counsel, or plaintiff's counsel, in their response to the motion, said defendant is not entitled to a set-off under 768.041, either because 21st Century was not a joint tortfeasor, citing Gowdy. So the very arguments were presented in the trial court. In terms of, and I'm not sure if counsel is suggesting that we had to actually prove this at trial or not, that's what the briefs kind of suggest. I would point out that there is a stipulation that was entered pre-trial that said the set-offs would be addressed post-trial. and that's at 2240 of the record. In terms of the same damages, Your Honor, yes, there are different claims here, but what we're talking about is the exact same damages. And I point to three things here: the complaint, the statute that we talked about, and the case law interpreting it. In the complaint, they expressly requested recovery in the bad faith claim for the damages suffered as a result of the crash, the same damages sought against Ms. Ellison. The statute, which counsel mentioned, 627-727 subsection 10, the legislature said that the damages recoverable against a UM insurer in a bad faith case are all the claimant's damages, whether caused by the insurer or the tortfeasor. So it's not just a measure of damages, it is the damages caused by the tortfeasor which are made recoverable in the bad faith case. And that's what the courts have said. In Geico versus Patton, the 4th District said that the damages in a first-party bad faith case include the total amount of the plaintiff's damages that were caused by the original third-party tortfeasor. It relied on this court's decision in State Farm versus LaForest, which acknowledged that was the same thing that the legislature provided for. Patton was then approved by this court in the Fridman versus Safeco case, where the court said you don't have to prove it twice. Once you've proved... Right,
Sorry, you got to finish up. You can take 15 seconds to...
All right, thank you, Your Honor. We just ask that the court answer the question, the certified question in the affirmative, and indicate that Ms. Ellison is entitled to the $4 million set-off. Thank you, Your Honor.
Thank you. Our final case today is number 22-210, Bevel versus State of Florida.
Thank you, Your Honors. May it please the Court, I'm Barbara Basharis, representing Thomas Bevel. I've asked to reserve 5 minutes of my time. Mr. Bevel is asking this Court today to vacate his sentence of death. I should say his sentences of death. He has 2 death sentences that were imposed for the killings of 2 individuals, and one of them being a 13-year-old boy. The first reason that the first argument I'd like to talk to you about, and I'm going to rely on my brief for a couple of the arguments raised, is that the Court abused its discretion in disregarding uncontroverted expert testimony about Mr. Bevel's extreme mental and emotional distress in the form of ongoing depression and post-traumatic stress disorder. The trial court appears to have disregarded uncontroverted expert evidence for possibly 2 reasons. One, looking at the mitigating circumstances in the sentencing statute. Excuse me. The court appears almost to have collapsed the factors that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance, with the separate factor that the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. These are two separate factors, and the factor that was charged and on which the jury was instructed that was argued at trial was B, 7B, that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. In support of this factor, the defense offered extensive expert testimony that was not rebutted by any state expert, and the bulk of that as to this factor came from testimony of Dr. Gold, who explained that the defendant suffered from post-traumatic stress disorder and depression linked to numerous traumatic and adverse childhood experiences in Mr. Bevel's background. His mother's death, drug use, exposure to domestic violence, exposure to physical and sexual abuse as a child, and substance abuse. The trial court was somewhat dismissive of the expert opinion as being based on self-reporting, because it is true that some of the expert testimony at trial was based on Mr. Bevel's self-reporting of numerous head injuries that he had suffered as a child and a youth. But Dr. Gold's opinion about post-traumatic stress disorder and ongoing depression was corroborated not only by two other experts, but by lay witnesses who corroborated the early exposure to drug use, corroborated some of the head injuries that Mr. Bevel suffered, corroborated the violence, corroborated the loss of his parents, his mother in an accident, his father indirectly to heroin abuse. And so his opinion was not just based on self-reporting. It was based on extensive records. It was based on extensive evaluation of Mr. Bevel. And as I said, it was not contradicted in any way by any evidence the state presented. The other expert opinions were provided by Dr. Wow, who testified to extensive testing that he did with Mr. Bevel, corroborating evidence of brain damage, and Dr. Negan, who reviewed scans of Mr. Bevel that again corroborated extensive brain damage and were consistent with the conclusions drawn by Dr. Gold.
And the court found mitigation on that basis, right? In the sentencing order?
The court found some, they called it non-statutory mitigation of brain damage. Yes,
so it really raises the question of, it seems like from a harmless error, I mean, I'm not suggesting that I agree that there was error on the emotional disturbance part, but given that the court did take that into consideration and, assigned it the weight that the court thought was appropriate, it seems like it's kind of, it wouldn't have affected the outcome either way.
Your Honor, Mr. Bevel disagrees because the simple finding of brain damage, which was corroborated by or demonstrated by all of the experts, is much narrower than the statutory mitigator that the felony was.
But am I correct in understanding that the experts other than Dr. Gold did not opine concerning the existence of the extreme mental or emotional disturbance?
That's correct.
I mean, so Dr. Gold was all you have, the actual opinion that
in
existed.
terms of the opinion supporting that particular aggravator, that's correct, Justice Kennedy. His opinion was very clear and stated repeatedly that he believed that aggravator was satisfied.
Well, wasn't he also very clear that he really hadn't examined the defendant here in the context of this crime? He was simply looking at the circumstances that created the PTSD and depression, and not linking that up in any way with the circumstances of this crime, and no explanation of how that could result in what was manifested in this case.
I can agree with that to a point, Justice Kennedy. I believe
I think some of it that's kind of clear.
I believe he did explain how Mr. Bevel's background brought him to a point of committing these crimes of violence. I believe.
But essentially, he was saying that because of that, he was always on the verge of doing something like this.
He was exactly, Your Honor. He was always under the influence of extreme mental or emotional disturbance. That was his opinion, that he had untreated post-traumatic stress disorder and depression that he lived with constantly, including at the time of the offense. What he declined to do, and what we're saying the statute does not require, is he declined to draw a direct nexus between the mental and emotional disturbance and the specific crimes committed. Because there is nothing in the plain language of the sentencing statute saying that nexus has to exist. The mitigation, particularly this subsection 7B of being under the influence of extreme mental or emotional disturbance, does not require that the extreme mental or emotional disturbance caused the crime. It requires that it exist and that defendants suffer from it.
If we accept the argument, even in its purest form, that there is uncontroverted evidence of the PTSD and depression, haven't we before held that if there's evidence on the part of the defendant of purposeful conduct like concealment, that the trial court doesn't abuse its discretion when it nonetheless rejects the uncontroverted evidence of the kind you're describing? Isn't that our law?
Your Honor, I believe that the cases that have done that are again, and some of us do it more clearly than others, they're collapsing subsections B and F into the same factor. If you look at subsection F, the capacity of the defendant to appreciate the criminality of his or her conduct or to conform his or her conduct to the requirements of the law.
So you'd ask us to recede from SPAR, for example?
I think that this court has other precedent that's completely consistent with what I'm saying. The Duncan decision is one such decision that I think was mentioned in the briefs, where the evidence of purposeful conduct is what refutes the mitigator that the defendant could not conform his conduct to the requirements of law. If you have that evidence of purposeful concealment, for example, afterwards, that shows that the defendant could, in fact, control his conduct, direct it purposefully. But I think the better precedents, which do exist from this court, are the ones like Duncan that recognize that refutes subsection F, that the subsection B about being under the influence of extreme mental or emotional disturbance is what allows mitigation. For example, when somebody would not be able to prove an insanity defense but is still under the influence of an ongoing condition that affects their behavior, their comportment. So the one may have, subsection F may have more of an implied nexus in the sense that if you are looking at purposeful conduct, as this court has done, you would be looking at it in the context of a specific crime. But there is no nexus requirement in subsection B. And Dr. Gold was very clear when pressed on this several times.
What does the word influence, what work does that do? It is under the influence.
Mm-hmm. When the defendant was, under the influence of extreme mental or emotional disturbance?
I mean,
that condition was present and was affecting him. And that's exactly what Dr. Gold said. He said it was true before and during the commission of the crimes. Mr. Bevel suffered from conditions that were ongoing. It's like having, untreated diabetes. You don't stop having it for 2 hours and then have it again. It's an ongoing condition. So Mr. Bevel's condition was also ongoing, and clear testimony from the expert that he was under the influence of those conditions at the time the crimes were committed was disregarded by the court. And that's why, Justice Muniz, going back to your question, the fact that the trial court did acknowledge the also uncontroverted evidence of brain damage does not cure the error in disregarding uncontroverted expert testimony about the emotional disturbance, mental or emotional disturbance mitigator. You have no further questions on that mitigator. I was going to move on to the second part of the argument, which is the jury instruction, a requested jury instruction. Thank you, Your Honors. The jury instruction argument is, I think, very straightforward. This court has rejected similar arguments in the past. We believe that the court should reconsider that rejection in the context of the way the different parts of the current jury instructions work together. Mr. Bevel requested an instruction that encompassed some language that is in the standard instructions. He would have instructed the jury, you must consider whether the aggravating factor or factors sufficiently outweigh the mitigating factors you have found. That's consistent with the standard instructions. Regardless of your findings as to aggravating and mitigating circumstances, you are neither compelled nor required to recommend a sentence of death. That's verbatim in the standard instructions. He would have simply added, before that, you have complete control and discretion in determining whether the circumstances of this case justify a sentence of death. And then after that sentence, you may always consider mercy in making this determination.
I don't see how that really adds much to the standard instruction. I mean, I understand you may want to do it and you want to kind of drive it home, but I'm struggling to see how that really adds, because that last sentence in the standard instruction, I mean, the inescapable inference from that is you can show mercy. I mean, you don't have to impose it, even though these factors would weigh up and say, well, it ought to be imposed. So I'm just,
and Your Honor,
again, I understand why you would want it, but I just don't really understand that you get any materially significant additional, anything materially different that's additional than what the standard instruction gives you.
And Your Honor, if that were the last thing the jury were told, I would have a harder time responding to your question, but it's not the last thing the jury is told, because after the jury hears that and the court goes through all of the other instructions on weighing and balancing that has to take place, the jury gets general instructions that says you must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. Your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits and evidence and these instructions. Your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone, a line about don't hate the lawyers, and then a final instruction, your decision should not be influenced by feeling of prejudice or racial or ethnic bias, and again, your decisions must be based on the evidence and the law contained in these instructions.
I guess, so my question here is, this is all reviewed for abuse of discretion, right? Okay. Let's say the judge adopted your proposed jury instruction in part. Help me identify what part of what you're arguing for was an abuse of discretion. Did the judge have to adopt your jury instruction word for word as proposed? Because it seems to me like perhaps you could make an argument that the ordering of the provisions would make things clearer, more favorable, less favorable, but we give trial courts discretion about this. Help me understand what you're saying is abusive about what the court did here, because I'm not seeing that.
Thank you, Your Honor. The abuse of discretion is that in the context of the final instructions I just read, that line about you're never compelled or required to impose a sentence of death really does not convey that a juror individually can bring mercy into the equation. We talk about it.
Help me understand that. How is it that a trial court abuses its discretion when it says to the jury, you're not compelled to do something? How is that an abuse of the trial court's discretion?
To say that by itself, I don't think is an abuse of discretion, but then to go on and limit with those general rules saying that you have to follow the law and only the law that's given to you here.
That sounds like an abuse of discretion. You have to follow the law?
No, but when that leaves no room for a consideration of mercy, when you're telling the jury at the end, you can only decide based on what you heard basically in the four corners of the courtroom. You cannot bring your own sense of extending mercy into this decision.
Don't we ask juries all the time to limit their consideration in a case to the evidence presented? I mean, how is that?
Absolutely, but what's different here, Your Honor, is that this is a life or death decision, and that we recognize.
You're saying that if contrary to fact here, the judge had said you're free to consider things outside the four corners of this courtroom, including, what you think about, the state of American society, that somehow would be less abusive of discretion?
No, Your Honor, that I would not argue that to you. What I would argue is that the requested jury instruction that you may always consider mercy in making this determination was appropriate, was legally correct, and would have served as a counterbalance to the rest of the limiting instructions, especially the line, your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Because if you just have a juror who has heard the type of mitigation that is presented in many of these cases, you see them as I do. Mr. Bevel's case had extensive mitigation. Mr. Bevel had a childhood that none of you would wish on anyone. And to tell the juror at the end of the mitigation case, basically, when they're retiring to deliberate, you can't base your decision on feeling sorry for anyone, removes that element of being able to extend mercy based on the defendant's circumstance. And so yes, I'm not arguing, Justice Curiel, and I don't want to overstate that the jury should be able to consider anything or bring in their views of what's going on outside the courtroom. That would be almost a form of jury nullification. What I'm arguing is that these standard instructions, especially with that final line in it, do not adequately tell the jury what it can consider in reaching its decision. Our law says that the jury can always extend mercy. This court, the U.S. Supreme Court, has repeatedly recognized that a jury can always extend mercy. But that single line that you're not required to impose a death sentence when it's followed by you can't make a decision based on feeling sorry for anyone does not adequately tell the jury that it can extend mercy.
Isn't the whole scheme of mitigation really about mercy? That we're going to take all these things into account that really are not necessarily directly related to the circumstances of the crime and what, by some objective standard, might fit that crime. We're going to take into account what fits this defendant and where the defendant has come from and all those circumstances. And it seems like to me that that's the sort of that could be conceptualized as showing mercy based on the mitigating factors.
It could be conceptualized as showing mercy, but if you don't tell the jury that's what they can do, you can't assume.
But you're telling them they can take all that into account.
That they can take it into account in balancing it against the aggravation. Right. Yeah, they absolutely are told they can take it into account.
And then they're told that even once they take that into account, they still don't have to impose. There's nothing about that requires them to impose a death sentence.
They're not required to vote to kill somebody, but they can't base their decisions on feeling sorry for someone. So what does that do? That leaves a conundrum. If you feel sorry for the defendant, and if you think that might be a reason to spare the defendant's life, you've just been told you can't base your decision on that. So yes, I'm not required to sentence this individual to death, but I've just been told that my reason for not doing so is unacceptable. So that's where the law leaves me.
Thanks. You can have 2 minutes for rebuttal.
Thank you, Your Honor.
Good morning. May it please the court, counsel. My name is Doris Meacham, and I'm here on behalf of the state of Florida. To address the first claim regarding the extreme mental or emotional distress claim, there was competent, substantial evidence for the trial court to find that Mr. Bevel was not under the influence of any mental or emotional disturbance at the time. He took into consideration the testimony of all three experts, in particular Dr. Gold. And what he found was that none of the experts had ever spoken to Mr. Bevel about the circumstances of the crime. None of them knew what happened. None of them knew what was going on through Mr. Bevel's head at the time of the crime. And based on this court's precedent, that is necessary. Dr. Gold was the only one whose opinion was that Mr. Bevel was under the extreme mental disturbance of PTSD. But he made it very clear that he based it on the fact that he suffers from PTSD or is diagnosed with PTSD, and that doesn't go away. But he was very clear that he was not making a connection between the PTSD and the reason for Mr. Bevel committing the crimes. And as Justice Kennedy stated, what is under the influence? Just because he suffers from or is diagnosed with PTSD does not mean he was triggered or under the influence of the PTSD that evening. In fact, as the trial court stated, everything points to the opposite of that. No one can testify that there was any commotion, any argument, anything to trigger Mr. Bevel that night. In fact, Mr. Bevel, from the testimony, got up at 3 o'clock in the morning, knocked on Mr. Stringfield's door, surprised him, and shot him in the head, point blank, killing him. There was no provocation. There was no argument. He then proceeded to shoot at Miss Smith, who was in the room with him, over 13 times, no provocation, and left her what he thought to be dead. He then went out into the living room where Mr. Stringfield's 13-year-old son was sitting on a couch with a remote control in his hand and shot him twice, once in the head. No provocation, nothing that would trigger PTSD. The judge also took into consideration Mr. Bevel's actions after the murder. He proceeded to ask Ms. Dumas, who was also in the home, to leave with him. Reason he did not kill her was because she was pregnant with his child. Before he left, he secured the front of the door with a burglar bar, which made it difficult for anyone to enter the home. He had the thought to leave with Ms. Dumas because in the back of his head he knew that he could convince her to be his alibi and to change her story to comport with his. He was able to evade the police for over a month. And when he was finally caught, he had multiple stories about what happened that evening. From I didn't hear anything, from 2 other people did it, to Mr. Stringfield was going to kill me, and I was in fear. None of that was substantiated through the testimony of the surviving victim, Ms. Smith, or by Ms. Dumas. In fact, it all corroborated the fact that this was an unprovoked murder on both victims. The court also
I'm thinking about this. Under the defense's theory about this PTSD, if the defendant here had put out a contract hit on someone, just because they had a score, he had a score to settle over some debt or something like that, under Dr. Gold's theory, that would be under the influence which just
Right, the fact that he walks around.
Right, because he's got it all the time, and what it's like anything he does.
Anything he
is,
does
is because of that.
Right.
It seems to prove a whole lot too much.
Right. I would compare it to someone who has cancer every day and has a heart attack and dies. The cancer didn't cause the death. The heart attack did. The fact that he's walking around with PTSD does not explain what he did that evening without actually having spoken to him and gotten some information. And as he said, I mean, Dr. Gold specified that the reason he was testifying was to gather mitigation for the defense, which he did, because everything he testified to regarding his upbringing, the sexual abuse, the growing in a neighborhood full of violence, being shot at, all of that mitigation that Dr. Gold found was also found by the trial court as non-statutory mitigation. So all of that was actually considered by the court and given very little to no weight. So I don't believe that Mr. Bevel has proven that he was under the influence of any extreme mental or emotional disturbance at the time of the murders. Are there any more questions on that claim? I will answer as to the next claim, which is the mercy rule, which by all accounts, 7.11 is considered by this court as the mercy rule. The instruction proposed by Bevel was not required to ensure the consideration of mitigating factors, and the failure to give special instructions does not constitute error where the instructions adequately address the applicable legal standards, which this jury instruction did. And additionally, defense counsel was able to argue mercy. As he stated in his argument, it is a godlike decision, and I urge you that if you go back to that deliberation room and you're sitting on the fence as to what truly would be appropriate in this case for Thomas Bevel on this day, I urge you to err on the side of mercy. And the law, of course, contemplates mercy, because the law repeatedly tells you, and His Honor will actually utter the words, as he did in jury selection, and before we even started this trial, the law neither requires nor compels. This was an accurate instruction, and there was no abuse of discretion. If there are no further questions, the state would respectfully ask that you affirm Mr. Bevel's death sentences. Thank you.
Thank you, Your Honors. Yes, the experts did not talk to Mr. Bevel about his state of mind at the time of the murders or the details of the murders, but Dr. Gold testified unequivocally that Mr. Bevel was suffering from post-traumatic stress disorder. There's the idea of being triggered, that somehow post-traumatic stress disorder doesn't affect you and then you blow up and do something and then you go back to normal, is something that might come from, you know, a police show or a TV show, but it's not how post-traumatic stress disorder works. And Dr. Gold explained that in his testimony. This condition was ongoing and was influencing Mr. Bevel, both at the time of the killings and before and after. So if anything, if you were looking at whether there was something to trigger him, that might be getting you into the realm of subsection F, where somebody became unable to control himself or conform his conduct to the requirements of law. But we're talking about subsection B, which does not have the same requirement. Justice Kennedy, your question about putting out a contract is interesting. What I would just take issue with is saying anything he does is because of his PTSD. No, that's not what we're saying, and that's not what Dr. Gold was saying. But I think it is conceivable.
Well, he's
that-
saying it's influenced by it. I mean, if he finds that, if he
influence, causation
finds
is
that the
different.
aggravator exists, he is saying it is influenced, right? It was influencing him.
But not necessarily causation.
Well, then
So-
how is it mitigation then? I mean, there has to be some connection, or otherwise none of it. I mean, we have to understand what the legislature is getting at in the context of what the point of the whole listing
What
of the
what the
mitigating
legislature is
factors
getting at with the list of mitigating factors, that there are various circumstances that may make somebody less culpable than another individual. There are various factors that may
Right, and
justify
the only thing
not
that would
killing
possibly
them.
make it relevant to culpability is if it actually affected what happened.
I disagree, Your Honor. I think then you're imposing a nexus requirement that does not exist and has been rejected. So,
Okay,
Thank you.
thank you. We are adjourned for today. Thank you.